Good morning. Today we are going to analyze one problem question on criminal law, the Sexual Offences Act 2003. Disclaimer: the video content has been made available for informational and education purpose only. Kindly go through this slide completely. Discuss whether Adam, B, C, and D could rely on the consent of the complainant if charged with a sexual offense under the Sexual Offences Act 2003 in the following situations. A and D are married. One night, A begins to have intercourse with D when she is asleep. D wakes up during the act of intercourse. She is horrified and tells A to stop. A immediately stops the intercourse. Scenario 2: B meets S, an aspiring model, at a bar. B tells her he is well connected in the world of fashion, and if S has sex with him, he can help her become famous. S agreed to have sex on the condition that they use a condom. After they have intercourse, B admits he works at the local supermarket and has no connections. Unbeknown to Sally, B removed the condom during the intercourse. C and A meets at the party. A does not normally drink alcohol but decides to have drink. She asks C for a glass of wine. C, who knows A is unaccustomed to drinking, gives her a strong drink of vodka. After two drinks, A is intoxicated and unsteady on her feet. They have intercourse that night, but the next morning, A has no recollection of it. D, the scenario 4, D owns a series of houses that he rents out to the low income tenants. One of the tenants is C, a single mom who has recently lost her job. C tells D she cannot afford to pay the rent or to buy food for her younger son. D says he will not charge rent that month if C has sex with him. Fearing she will be homeless, C agrees. Let's analyze each and every scenario in detail. The issue of consent under the Sexual Offences Act 2003 (SOA) is central to determining whether A, B, C, and D can rely on the compliance consent in their respective situations. Section 74 defines consent as an agreement by choice with the freedom and capacity to make the choice. Additionally, Section 75 and 76 establish evidential and conclusive presumptions, respectively. Let's analyze the first scenario, the Adam and the Daisy case. Under the Section 75 2D of SOA 2003, a rebuttal presumption arises that there is no consent if the complainant is asleep or unconscious at the time of the sexual act. A engaged in intercourse with D, which while she was asleep, although D later awoke and expressed her non-consent. The presumption of non-consent remains operative unless rebutted. In other words, a reliance on D's consent is undermined by the Section 75(2)(d) of SOA 2003, which established a rebuttal presumption that a person does not consent if they are asleep or unconscious. The fact indicates that D was asleep when A began intercourse and only woke up during the act, making this presumption applicable. While the previous consensual behavior may reboot this presumption, and Daisy horrified the reaction suggests that there was no prior agreement to engage in sexual activity while she was asleep. Furthermore, intercourse is a continuing act as clarified in Katami Key versus R in 1985, meaning that consent is required for the duration of the act. Even though A stopped immediately upon D's objection, a lack of consent the act's commencement and continuation renders the situation non-consensual. A's belief is these concerned would also likely be deemed unreasonable under the circumstances, precluding him from relying on the defense of a reasonable belief in consent. In other words, R versus Kaitamiki in case in 1985 establishes that sexual intercourse is a continuing act, meaning A's liability arises even though he immediately stopped when D is objected. D's horrified reaction further negates the possibility of A reasonably believing she concerned as required under the section 11C, while the frequent consensual behavior in similar circumstances could rebut the presumption. Example, the pre-established consent. This is clearly absent here. Therefore, A is unlikely to successfully rely on consent defense. Let's move on to the second circumstances, B and C. In B's case, yes, initial agreement to intercourse does not constitute valid consent due to B's removal of condom without her knowledge, a practice referred to as stealthing, which deceptions as to the job status does not negate consent under the Section 74 as established in Lawrence 2020. The removal of condom significantly alters the nature. Rather, while deceptions as to job status does not negate consent under the Section 74 as established in Lawrence 2020, the removal of condom significantly alters the nature of the act. In R versus DPP in 2017 and Assange versus the Swedish Prosecution Authority in 2011, the courts held that conditioned concern, such as a consent contingent on the use of the condom, means that violating those conditions vitiate concerns. The yes agreement was based on the condition that a condom would be used, and this condition was not met. B's act of removing the condom without her knowledge or agreement satisfies the requirement for vitiating the consent under the Section 74, and thus he cannot rely on her consent as a defense. In other words, in B's case, the relevant issue concern the deception conditional consent under the Section 74 of SOA 2003. As yes, agreement to intercourse was conditional upon B's using a condom, and his deliberate removal of the condom during the intercourse vitiates her consent. This aligns with the principle in A versus Swedish Prosecution Authority in 2011, where removing a condom, contrary to an explicit condition, was held to invalidate the consent while B also deceived S about his profession. The case of R versus Lawrence in 2020 clarifies that deception about the external matters, such as social or professional status, does not generally vitiate concerns unless it pertains to the nature or the purpose of the act. Since B's deception about his job is unrelated to the physical sexual act, it does not invalidate his consent. However, the deliberate breach of her condition regarding the condom use renders her consent void under the Section 74, leaving B unable to rely on it. The third category, Colin and Anna, since the reliance on A's consent is questionable about Section 74 and 75 of SOA 2003. Section 75 2D create a presumption that a person does not consent if they are unable to communicate their consent due to intoxication. Here's Anna's service severe intoxication resulting in her lack of money of the event suggests a loss of capacity to consent. As discussed in R versus Bree in 2007, the court in Bree emphasized that If a person loses the capacity to make a choice due to intoxication, they cannot consent under the section 74. C's awareness of A's lack of drinking experience and his provision of strong alcohol indicates that he may have deliberately facilitated her incapacity, while the presumptions under the section 75 may be rebooted if it can be shown that A retained the capacity at the time of intercourse. The evidence points to her inability to consent freely and by choice, rendering C's reliance on consent invalid. In other words, the central issue in C's scenario is whether A, who was intoxicated, retained the capacity to consent under the section 74, and whether evidential presumptions under the section 75 2D might apply. His intoxication raises the question about her ability to make a free and informed choice. According to R versus Bray in 2007, the intoxication does not automatically negate the capacity to concern. However, if a person becomes so intoxicated that they lose the capacity to make the decisions, they cannot concern. Here, Anna's unsteadiness and subsequent memory loss suggest she may have lost the capacity to the concerned, and C's knowledge on her lack of experience with alcohol and his provision of strong vodka could further undermine the validity of consent, as he may have exploited her vulnerability. In section 75(2)(d) applies, example, due to the involuntary intoxication, the presumption of non-consent is rebuttable only if C is reasonable believed A is consent. Given her intoxicated state, it is unlikely he could reasonably hold such a belief. Let's analyze the final scenario, a doll versus Cindy case, where the doll's conduct raises issues under Section 74 of SOA 2003, which emphasize the agreement by the choice and the freedom in making that choice. The C's agreement to intercourse was made under duress, as she feared eviction and homelessness. In R versus Boja in 1982, the court distinguished between the reluctant submission and genuine consent, emphasizing the need for the freedom in making the decision. Similarly, in Kirk case in 2008, the court held that the sexual activity induced by exploitation of a victim's desperate circumstances does not constitute a consent under the Section 74. So the doll's use of Cindy's financial vulnerability to the cause her into the stakes undermines her freedom to choose, making her agreement involuntary. Thus, D cannot rely on Cindy's consent as a defense under SYA 2003. In other words, D's action raises question under Section 74, specifically whether C's agreement to intercourse was made freely and by choice. The case law such as R versus Olugja in 1982 emphasized that submission due to pressure or the coercion does not constitute a consent. Sees fear of homelessness and her obligation to care for her child likely impaired her freedom to make a genuine choice, rendering her concerns invalid. Further, cases like R versus Kirk in 2008 highlighted that a consent obtained through exploitation of dire financial circumstances is not a true consent under Section 74. A disproportion to waive the rent in exchange for the sex closely mirrors the coercive circumstances in Kirk, where the court held that compliance a dire situation undermined her freedom to choose. Thus, D cannot rely on C's consent as it was procured through coercion. To conclude, in all the four scenarios, the defendant faced significant legal obstacles in relying on the compliance concerned under the SOA 2003. Adam's case involves a rebuttal presumption under Section 752D, which is likely to be rebutted. Bazard vitiated a Sally's concerned by violating the condition of condom use. Colin cannot claim a valid consent due to Anna's incapacity from intoxication, and Adi's exploitation of C's financial distress negates the freedom required for valid consent. Each situation demonstrates how statutory provisions and case law apply to assess the validity of consent in sexual offences.